Please, Your Lordship. My Lord, I beg to make a mention of item number 6.
What is item number 6?
My Lord, this matter, Lordship has heard me, and my friend is supposed to give his
my Lord, this is the LA matter, my Lord. It's taking two more weeks' time, my Lord.
Why?
Only for the citation, because my friend has raised certain issues, my Lord, very tricky issues regarding the notification. Because what had happened is, my Lord, the initial notification was 1983. Then subsequently the notification was modified. So subsequently I have come to High Court. That order of modification and corrigendum was set aside by the High Court. So the special judicial officer has relied on that corrigendum for assessing the rate of the prevailing rate. So in that aspect, I'm looking some because my friend has cited some citations. So I'm looking for that citation. Because then it'll go, because that is a gap of almost 7 to 8 years, my Lord. The corrigendum has come after 7 to 8 years, my Lord. The initial was 1983. So in that aspect, my Lord, I'll have to satisfy your Lordship whether 93 corrigendum will be applicable or not, my Lord. Only for that aspect, my Lord.
Corrigendum of what? Notice under section 4 or 6?
Section 6.
Six.
Section 4 was 1983, and subsequently Section 4. So Section 6 corrigendum in 1993. So collector has made an assessment from 1993. That was the date of the Section 6.
Section 6.
What is the then the consequential effect of section 9 and 11?
Well, what happens
that
is
was taken care of.
The area has been reduced by the corrigendum, my Lord. After we have approached the High Court, that's why, my Lord. That's why the corrigendum has come into play, my Lord. Initially, it was for 5,000 square feet.
The area of acquisition.
Yes, ma'am.
Very precision.
So that is the only issue which my friend is relying upon, my Lord, with regard to the quantum which has been awarded to me by the special judicial officer. After 2 weeks, my Lord, I'll just see if I can get some authority on that, my Lord. The rest of it, my friend is not disputing in as far as other award which has been given to the buildings and all. Only with the quantum of the award my friend is disputing.
On prayer made by Mr. Al-Krim, the counsel for the respondent, seeking accommodation on grounds of personal difficulty. The same not be objected to by Mr. H.L. Sangrisula, senior counsel for the appellant. Matter is adjourned. This is after 2 weeks.
Please, Your Lordship. Lordship, I beg to mention item number 7 of the daily list. Conducting counsel Mr. S.N. has some personal difficulty today, my Lord. This matter may kindly be taken up next week, subject to Your Lordship's convenience, my Lord.
Because personal
That execution
matter. Yes.
I can do it. Yeah, change the counsel. 2 weeks, then?
2 weeks.
On supplementary list, item number 1.
Morning, Lordship.
What is required here?
Lordship.
What is required here?
Lord, here we have filed an objection in this bail application. So
You have filed an objection.
we have already filed. They said they will be replying because this petition is not maintainable.
Better. Too many points.
Okay.
We have a daily.
You filed reply?
I have not, Your Lordship. Primarily, three contentions were made in this objection. Firstly, that it is not maintainable on account of the petitioner having had signed the application, and
Oh, because he has to sign it himself.
absolutely. So that was a point raised. So I believe that this point could have been covered verbally, Your Lordship. However, Your Lordship, if it is for the sake of convenience, I believe it would be better to file a rejoinder. I feel now at present that is what I feel, because there are a lot of quotations as well.
Yeah, because if a point of law is raised, then you have to cite authorities.
Yes, Your Lordship. So in that case, I think if I may be given time to file a rejoinder, I was not keeping that well too during this past week.
So when?
I can file it by Monday. Sorry.
So we'll list the matter on Tuesday.
Wednesday, Your Lordship. I'll file it by Tuesday maximum. In case, I'll just keep one day.
Wednesday will not be possible. Then we'll have it on Thursday.
Thursday. Check. I think it would be more convenient if it's filed.
Mr. S.S. Seda, Learned Counsel for the petitioner, has submitted that the rejoinder to the affidavit filed by the state respondent could not be filed today and has sought for time to file same and has sought some more time to file such rejoinder. Pray aloud. As prayed for, list this matter on. Let the rejoinder be filed within the next date fixed. As agreed to by the parties, list this matter on 24th.
Oblige.
Highly oblige.
On daily list, item number 1.
Lordship,
Yes.
Lordship, I need to do the means I was to do the research, and it is refixed today, as our Lordship was not satisfied on my grounds, Lordship, for the continuation of delay, Lordship.
Oh, because of such, so many days of.
Yes, Lordship. It was so many days delays, Lordship. The
So cause has been filed.
show cause has been filed.
Already filed. We argued on last week, Your Lordship.
Oh,
Yes, Lordship, show cause was filed, and also after filing of show cause, the argument was raised, Lordship. Lordship, here I'll furnish the copy of the award, Lordship. Actually, Lordship, I'll need some more time also, because today I'm not keeping that good health, Lordship. I'm not in a good health to do argue the matter also.
when do you want?
But 2 weeks time maybe, Lordship, and by that time I'll just furnish the copy of the award, Lordship, based on which the judgment was arrived at.
Furnishing copy of the award will not help. It is
Lordship.
what the record says will matter. If you, as you say, there is no award on record,
Lordship,
then this court may have to look into that aspect of the matter.
Lordship, there is no
As to
copy
how
of
the
the
collector has, firstly referred the matter.
Lordship.
Secondly, how the special judicial officer has taken up the matter in absence of the award.
Lordship.
How
Lordship, that is
how
why,
evidence
Lordship, I
recorded?
was stressing on to call for the records, because I have personally checked the records on similar matter when the matter was listed, Lordship, the Sabita Devra's case. Lordship, I personally checked the entire record, Lordship.
I think that has been, as far as the award not being, on record.
Lordship.
If I recollect, in that case,
Lordship.
the collector,
Subsequently, collector has filed.
the council has
Yes.
admitted that it was not on record.
Yes, Lordship. And
And it was just
after
produced like that.
Lordship, consequently, Lordship, I on this case also, Lordship, I checked the record. Award was not there, Lordship.
But the only thing you see, when you come before a court for condonation of delay, sufficient cause has to be shown.
Lordship,
And you see, the issue, the question of laches, acquiescence have to be considered as to your conduct. Forget about the facts and circumstances, but you see, your conduct has to be looked into as to what prevented you from coming to court in time. So that only that aspect is to be considered. Whether the award is there or not, if the matter goes on merit, then yes.
Lordship, there is also, I'll furnish one more, I'm researching on that, Lordship. Actually, what happened, Lordship, there was a CBI proceedings also, Lordship, for which all the records from our office was taken by CBI, was seized by CBI. Later on, it was, subsequently it was released.
Have you noted down in your
Lordship? Here I have noted, because I was not having the case number, Lordship. Now I have the case number, Lordship. Subsequently I'll through one affidavit, I'll bring the case number along with the copy of the charge sheet where it is the CBI case was also registered. So since the case
anyway,
was,
you are not well, so how come you speaking so strongly?
Lordship,
Lordship, firstly, they have to cross the hurdle of condonation.
Lordship,
Without going into the technicalities or facts.
We are on that.
Lordship, I'll submit, Lordship.
1 week's time was granted.
Miss Procedural counsel for the applicant has something at the bar that she is not prepared to be heard in this matter today, as she is not keeping well. It is also the assumption of the counsel that the applicant may be allowed to file an additional affidavit to bring certain facts on record, supplementing the causes shown as to why the related appeal could not be filed in time. As prayed for.
Lordship, I may be allowed to bring through one small affidavit.
Sir, I have allowed you.
Yes, Lordship.
Do that.
Yes, Lordship.
And you give an advance copy to them.
Lordship, I'll give an advance copy.
This is matter of 2 weeks.
Lordship. Obliged.
Item number 2.
The respondent number 5 and 6, 4, 5 and 6, Malot.
I'm waiting for the respondents by the respondent.
This petition has been admitted.
Yes, Malot. Admitted.
Only have you filed your counter?
They have not filed the counter.
Necessary, my lord, if Lordship will go to the Act, the Millennium Act.
Okay, before that, what is your case, Mr.
Yes. Malot, my case is that there was a delay in filing of the election petition, Malot. This is against the election petition of the same Millie, Malot. If my lord recollects, your lordship has given them liberty to approach this council for filing of an election petition. There was a delay of 730 days, my lord. So they have filed the application for conditional delay. That was condoned, my lord. Against that, I have come before this honorable court. 730 days, my lord. In a similar case, my lord, a delay of 46 days, that was not condoned.
Under such circumstances, is the law of limitation applicable?
Well,
or the spirit?
Spirit will be applicable, my lord.
Now, my contention, my lord, is in view of section 6 of the Act, of the Millennium Act 2007, page 320, my lord. We'll go to 320.
Yes.
A dispute regarding the election and confirmation of the same. If within 30 days of the declaration of the result by the returning officer, any dispute arises regarding any matter relating to or connected with the election of the same, the party or parties concerned shall by a petition refer the dispute to the tribunal constituted by the executive committee for the purpose. The tribunal shall dispose of the matter as early as possible and shall not ordinarily exceed 6 months from the date of receipt of the case records, which reports and findings shall be submitted to the executive committee for its final decision. Now, this is important, my lord. So, any report by the tribunal has to be submitted to the executive committee, who will decide whether it's right or wrong. I mean, the final decision is with the executive committee. And my lord, what has happened, the petitioners have come before this court only against the order of the one-man tribunal. What I am saying is that it's premature. Let the executive committee decide whether the order of, yes, it's a sort of a appellate authority, the executive committee, although it's not been stated here. But the final decision lies with the executive committee.
My lord, that will be after the inquiry only, my lord, in my respectful submission. My lord, this is with regard to condonation of delay, my lord. That will be
condonation of delay for approaching the tribunal.
No, 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 my lord. Yes, my lord.
Yes. But you said the in the meantime the tribunal has taken cognizance of the matter.
Before the moment the order was passed, I had approached this honorable court. See, the entire proceeding has been stayed, my lord.
Okay.
The moment the delay was condoned, my lord.
I can understand what Mr. Dindo is saying.
My lord.
That let the tribunal carry on with its function.
No.
And let the report be filed. Eventually, matter will be decided.
Even at this stage, even for the purpose of condonation of delay, whether the tribunal allows or disallow, then it should be placed before the executive committee to decide whether the action of the tribunal is correct or wrong. What I am saying, my lord, is that it's premature. The writ is premature.
No, my lord, but this is with regard to condonation, my lord. I can understand if it's the final findings of the tribunal, then only, my lord.
Which report? It says what? Which reports and findings shall be submitted to the executive committee for its final decision. That's the last.
This is not a report of finding, my lord. This is with regard to condonation of delay.
There is an ambiguity there,
my lord.
As far as the the procedure is concerned.
Yes.
Whether such such in such a situation where the condonation of delay has been allowed or disallowed, then what happens? There must be a procedure that usually there's an appellate authority for which any of the parties can approach.
Yes.
But it is not specifically spelled out.
Yes, yes, exactly.
So how do we what do we do? Then we look for precedents. Then we look we go into the nature of the case, apply the
principles,
the principle of natural justice, so on and so forth.
This is all interpretation of statutes, basically.
Yes, exactly.
Even otherwise also, my lord, even against the finding also, I cannot go to the executive committee, my lord. I'll have to approach this honorable court only. Because the executive committee either will accept or reject the findings.
In that case, then this court at this stage can refer the matter to the executive committee.
Yes.
To decide.
That's what I'm saying, my lord. I'm not saying they're wrong.
You are not left without remedy.
Your lordship.
You are not left without remedy.
Your lordship.
If because of these provision or the procedure not being specific, the court will now refer the matter to so as the party not losing any forum.
Yes.
Then what happens is the executive committee will decide whether in your favor or against you. That doesn't matter. Any of the parties agree, then can come to that.
Well, let me
and the merits will be.
Well, let me examine that aspect of it, what has fallen from your lordship.
Or on the other hand, you are also at liberty to approach the executive committee.
Your lordship.
If the executive committee rejects your application or accept, if it accepts it, well and good. If it rejects it, you can come before this court.
Well, I'll examine that aspect of it, my lord. Let the matter be.
No procedure is laid down.
Your Lordship.
Under what condition?
That's true, Your Lordship.
The only thing is that it talks about reports and finding.
Your Lordship.
So procedural, lapses cannot be termed as findings or report.
Your Lordship. Let me examine that aspect more. Matter we've taken after 2 weeks. I'll just see, like Your Lordship had said, that any precedent are there or not.
1 week.
Well, 2 weeks now. Let it be 2 weeks now.
Mr. Alfred, the counsel for petitioner has sought for some time to be heard in this matter on the ground that the petitioner may explore the possibility of approaching the executive committee for redressal of his grievance. Accordingly, as paid for, this is matter for 2 weeks.
Well, the interim order is there, 9/6, but that may
The
continue.
interim order in the meantime will continue until further orders.
Obliged.
Item number 3.
So the interim order will continue to be in force.
Lordship,
Yes.
at paragraph 62 of the judgment, the court has, the MACT has recorded a finding against me that
Page?
paragraph 62 of page 140.
Sixty-two.
62. The evidence of the claimant witness CW2 and CW3 is less believable by this tribunal, as CW2 stated that in the accident he was not in a position to open the door and came out through the window and he was badly injured, but contradicts himself in the cross-examination that he was not seriously injured. So his evidence is discarded on this point. That this contradiction is no contradiction. It doesn't relate to the accident or negligence in questions. At one place he says seriously, other place he says badly. The court has disbelieved the evidence of CW1.
And what does he say about negligence?
No, I'll come. I'm just praising the finding. CW4 has also stated that he saw the accident took place and narrated the accident before the police officer present at Civil Hospital, Nongko. But in his cross-examination, he stated that he did not inform the police on that day or any other day subsequently anything about the accident. He is examined in the court. He stated that what has happened in the accident, and the trial court has rejected his version also. Just on the ground that in the chief he stated that he has informed the police, but in the your lordship matter remained pending for 10 years in the MACT, and I have finished my witness within 2.5 years, and the insurance company took 7.5 years to complete their evidence, be that as it may be. Then 64, after weighing the evidence of both claimant and OP number 3 as discussed above, it is found that the accident was caused due to rash and negligent driving of the deceased husband of the claimant, who failed to stop on being signaled by OP number 2 and OP number 3, who were on Naka checking duty and then overtook the other vehicle and went to dash the stationary work, Your Lordship. So these findings, Your Lordship, are assailed under this appeal. There is one observation also at paragraph 61. Paragraph 61, also as per paper mark D, there was a smell of alcohol detected on the deceased. But this is an observation. Court has not given any finding, or this thing was, or if at all this thing was related to the negligence or accident of the vehicles. Your Lordship, the stand of the, so far the pleadings are concerned, I have pointed out that the stand of the claimant in paragraph 24 of the claim petition is this, that the disease, the Maruti, he was driving the Maruti car. The Maruti car was coming from Barnihat to Shillong site, and the truck was going from Shillong to Barnihat site. Both were in the opposite direction. And when they reached at Nongpo, the truck tried to overtook the other vehicle and dashed the Maruti car. And as a result,
when did this incident happen?
This in 2004, 2014, Your Lordship.
2014.
2014. That time the four laneway was under construction.
Okay.
Four laneway, it was under construction. It was there is evidence to that effect, Your Lordship. Now, this is the definite stand of the claimant in the claim applications, as I have read it on the last occasions. With regard to the insurance company, they have taken the stand in the written statement that since the police has registered only a UD case, therefore the accident was caused due to the negligence of the driver of the negligence of the deceased himself, and therefore insurance company or his insurees are not liable. So their stand is based upon the UD case. They say that since the police has registered only a UD case, therefore the negligence is to be attributed on the deceased himself, and he died because of his own negligence here. The tribunal has framed issues, and the first issue is relating to the accident, whether accident was involving these two vehicles, and in the same issue there is a issue of the negligence also, Your Lordship. Now, the information when it was received by the wife of the deceased that the police case has been closed on the basis of the FR submitted by the police, she has approached to the Chief Judicial Magistrate, filed an application before the Chief Judicial Magistrate that investigation was not proper. There were other, even the co-passenger of the Maruti car was not examined, and there were other witnesses who were not examined, and the matter requires re-investigation and registered as a regular case, and to investigation to be handed over to the other police officers. CGM has accepted the prayer of the wife, claimant and the appellant herein and order for re-investigation by registering a regular case. And in accordance with the direction of the court, police has registered a regular case, meaning thereby, your lordship, the finding of the UD case goes, because that was not accepted later on, and court has ordered for the re-investigation of the matter by registering a regular case. At here also, your lordship, the police, instead of registering a case against the driver of the truck, again registers a regular case against the deceased driver of the Maruti car. No case, your lordship, can be registered against a dead person. They ought to have registered a case against the driver of the truck and re-investigate the matter by taking fresh evidence. But what they did, they registered the regular case against the deceased driver, which carry no meaning, no sense.
Yes.
And IO of both the cases are different. For UD case, there is one IO, and for regular case, there is another IO. Insurance company has examined the witness of the UD case, two police officers. They examined who are the witness in the UD case, and the finding of which were not accepted later on by the CGM, and a regular case was ordered to be registered, your lordship. Now, your lordship, during the course of the hearing or a hearing of the or trial of the case, the insurance company has come up with 4 different stands. Your lordship, we take a note of these 4 different stands which they have taken. In the written statement, there is one stand by which they say that since the police has registered a UD case, therefore the accident was caused by the negligence of the driver of the Maruti car. Then second stand, they take it that the truck was parked on the road. It was not moving. And this thing is not in their statement. When they take over the defense under section 170, they do not file a supplementary written statement by taking other pleas. So first stand I have told, second stand there is this, that the truck was parked. Third stand, again they take it that truck was moving. That is again a contradictory stand. I'll show the evidence which they have adduced. Third stand they take that the truck was moving, and after seeing the Maruti car, it stopped, and Maruti car dashed against the truck. So 4 different stands they have taken during the course of the evidence. First, if your lordship permit me, I'll repeat once again, that in the pleading they take a stand that since the police has registered a UD case, therefore negligence on the part of the deceased driver. Second stand, that the truck was parked and not moving. Third stand, the truck was moving. Fourth stand, the truck was moving, and after seeing the Maruti car, it stopped. It stopped. And Maruti car came and dashed against the truck, Your Lordship. These are the four different stands which they have taken, Your Lordship. Now, in the No, I just take Your Lordship to the evidence of the claimant, CW1, though he is not an eyewitness, but she has given the file an application before the CDM for re-investigation of the case. Your Lordship, page 21. Page 21, CW1, that upon receipt of the copies of the accident information report and the FR from the Nongpo court, I had filed an application dated 4/11/2014 before the additional district magistrate Nongpo with a prayer to direct the Superintendent of Police Nongpo to register a regular case against the driver of the truck number so and so. And the said prayer was allowed and wide order date so and so. The Superintendent of Police was directed to make immediate actions, take immediate actions, that pursuant to the said order dated 6/11/2014, the police registered Nongpo PS case number so and so under section so and so. However, and most unfortunately, the police had, instead of registering a case against the opposite party number 2, the driver of the truck number so and so, registered the said case against my deceased husband, against the dead person, and once again returned the case in FR, wide FR number so and so, without taking into consideration the affidavit filed by the sole eyewitness, Shri Preston William. Now, Your Lordship will find that on this issue, on this statement, there is no cross-examination. There is no cross-examination so far. This part of the registering of the regular case is concerned. I have stated this thing in my claim application also. They have not responded to this paragraph. And yes, then Your Lordship, page number 26, CW2, he is a eyewitness. He is a eyewitness. He was a co-passenger in the Maruti car. Page 26. On 11/6/2014, I, along with the deceased late Colin Walgery, were coming from village so and so, Shillong, in a Maruti car number so and so. The said vehicle was driven by the deceased late Colin Walgery. I was sitting in the front seat. The deceased was driving the vehicle in a normal speed. We started from Umxiang at about 6 or 6:30 p.m. and we were driving on the left side of the road. When our vehicle reached at Nongpo police station, I saw one truck bearing number so and so coming from opposite direction and on wrong side of the road. By overtaking another truck, Your Lordship will find that over case is this, that the truck overtook the other truck in a high speed, dashed the Maruti car on its front side, and as a result the Maruti car was pushed back and stuck in a drain. I was not in a position to open the door. I came out through the window and I was badly injured and taken to civil hospital Nongko. But since my relatives like to have Khasi treatment, I refused admission. I came to know about the death of the disease from the staff nurse of the hospital. The disease was my friend, as my father is also working in the same office. So whether he took, I know the family of the disease. The disease is survived by his wife and 3 children. I did not find any smell of alcohol from the mouth of the disease, so I cannot say that whether he took alcohol or not. The contents of these affidavits were told. These are not so much relevant. Then, Your Lordship, in the cross at page 28, Your Lordship will find there is no cross on the point that the truck overtook the another truck. Allow me to read, Your Lordship, page 28.
Yes.
I have filed my statement on affidavit so-and-so. Exhibit 13 is an affidavit sworn by me. I know the claimant, who is the wife of the deceased late Colin Walgery. The claimant has 3 children, but I don't know the name. These are on 11/6/2014. I was with the deceased Colin Walgery in Maruti car belonging to him, which is a private vehicle, and the deceased was driving the vehicle at the relevant time. I did not report the incident to the police, although I came out of the accident with injuries on me. I don't know that the FIR in respect of this accident was lost only in the month of November 2014 by the complainant. This was not the FIR, Lordship. We have filed an application. When I was still at the place of the occurrence on the day of the incident, the police arrived and took me to the civil hospital. But I do not know what had happened to the driver, Shri Colin Walgery. After the police had arrived at the PO, I was not required to be admitted to the hospital and discharged very same day because I refused to take treatment from the hospital. I have treated myself with traditional Khasi medicine. I was not seriously injured. That is what the court has, that at one place he said badly, other place he is telling seriously. Injured in the accident, nor did I sustain my broken bones. It is a fact that the accident was not occurred due to the, it is not a fact that the accident has not occurred due to the rash and negligent driver denied, coming from the opposite direction. It is also not a fact that the accident had occurred due to rash and negligent driving of the Maruti car in which I was a passenger. It is not a fact that I have deposed falsely regarding the accident having been caused by the fault of a truck driver. I do not know that the police who have arrived at the PO immediately after the accident have found from the state of affair in the place of occurrence that the accident had occurred due to the fault of the driver of the Maruti car. And I also do not know that no regular case was registered in respect of the accident except the UD case. I cannot remember where I have signed when I have signed Exhibit 13. I also cannot say after how many months of the accident I have signed this Exhibit 13. The contents of the affidavit is with regard to my version of the accident, and I cannot recall when I have signed it and where I have signed. It is not a fact that the contents of this affidavit are also false and having no bearing to the truth. It is not a fact that I was not sitting in the passenger seat on the day of the accident. It is not a fact that I do not know anything about the accident. It is also not a fact that I have deposed falsely just to help the claimant myself. Your Lordship will find that there is no cross-examination or no challenge to the statement of the witness that the truck overtook some other truck. And
cross-examination decline?
No, Your Lordship, this is the cross-examination I am reading.
This is a process.
Cross-examination, and there is on this point that the truck overtook another truck and dashed against the Maruti. There is no cross-examination, and your lordship, there is also no cross-examination that the truck was not moving and it was parked. Nothing. According to the CW2, the truck was moving, and there is no cross-examination on this point that the truck was not moving, it was parked. Then your lordship, CW3 is the official witness who produced the records of the service book of the claimant of the deceased, which is not relevant. CW4 is again a eyewitness from the claimant side. He is a third party. He was there at the place of the accident.
So he was a bystander?
Yes. He was there. He went to the Nongpo and he was returning from Nongpo and he saw the accident. That I'm a carpenter by profession and mainly work in the Ribhoi district, Nongpo, and beside Nongpo, I also work in other places. Pardon? Page 33, your lordship.
Yes.
That I am a carpenter by profession and mainly work in the Ribhoi district, Nongpo, and besides Nongpo, I also work in other places. I know the claimant as well as deceased late Colin Wajri, who was the husband of the claimant. That on 11/6/2014 between so-and-so to so-and-so time, while I was waiting for a bus to return back to Shillong near Nongpo PS on GS Road, at that time, I saw a motor vehicle accident in which one Maruti car bearing number so-and-so coming from Banihart side was hit by a fast moving truck bearing number so-and-so, which was coming from the opposite direction and on wrong side of the road by overtaking another truck, your lordship. Even this witness says that he corroborates the evidence of CW2.
Yes.
I rushed to see the Maruti car, and since the driver and the occupant of the Maruti car were known to me, I stopped there and I found that the driver of the Maruti car, Colin Wajri, died on the spot. I also know the occupant of his occupant by his nickname, and his nickname is Bardeng, who was sustained injury. I went to the civil hospital Nongpo, where the disease was declared dead and Bardeng was released after some treatment. That I further state that since I have seen the manner in which the accident took place, as such I can say that the said accident took place because of the negligence of the driver of the truck, and I had also narrated the aforesaid incident before the police officer present at the civil hospital Nongpo. That the statement made by me so and so. Then in the cross, your lordship, what he says, that I am the mystery carpenter by at page 35, your lord. This is cross examination. I know the disease Colin Wajri as I used to see him when I go for fishing on 11/6/2014. I remember I had gone to Nongpo on being called by one of my relatives whose name I do not know. The disease used to.
Mr.
Pardon, sir?
You're reading
page 35, cross examination of CW4.
Cross examination.
I know the disease Colin Wajri as I used to see him when I go for fishing on 11/6/2014. I remember I had gone to Nongpo on being called by one of my relatives, whose name I do not know, but we refer to him as Bandhu for doing slab work. The disease used to work in PHE, but I don't know in what capacity. After the incident, when the police arrived, I moved away from the place of the occurrence and went to the hospital to see what had happened there. but I did not inform the police on that day or any other date subsequently about the cause of the accident. It is not a fact that I was not at Nongpo on 11/6/2014, nor did I see the incident as just stated. That suggestion is denied. After going to the hospital, I returned back to the Shillong. It is not a fact that I did not go to the hospital. I do not know anything about the incident. It is not a fact that the statement that I have given today is false. The Maruti car belonged to Disease Colin Wajri. I do not know that the police had not registered any case, but a UD case with respect to this incident. So your Lordship will find on the merit of the accident, there is no cross-examination, no challenge that the truck was not moving and it had not overtook the another vehicle, your Lordship. Now, your Lordship will find that my this statement was recorded on 17th May 2019. My evidence were closed.
17 May.
Yes, 17 May 2019. Then, your Lordship, they took 5 years to bring two witnesses.
Yes.
Your Lordship, OP number 1, page 36. She is Shrimati Jopika Nongsis. She is the IO of the UD case, who has submitted the FR and investigated the UD case. Now, this is the examination in chief. I received summon to appear. This is the insurance witness. When they took over the defense of the both driver and
Yes.
and did not file any supplementary written statement. I have received summon to appear before this court in the year 2014. I was posted at traffic cell in so-and-so. I received a telephonic call from the in charge of traffic Nongpo PS informing me when I had reached home and were informed that there was an accident but below Nongpo PS, that I was required there. This was around 9:15 p.m. Immediately. I rushed to the spot and on reaching there, your Lordship, I may point out, he is not an eyewitness. He did not see. He investigated the case. The accident took place between a Maruti car bearing registration number so-and-so and a truck bearing registration number so-and-so. On reaching in the hospital, I found the driver of the Maruti car has expired and the occupant of the said car refused to be medically examined by the doctor. And after some first aid, he was released. The vehicle had been removed from the place of occurrence as it was a highway and caused a lot of traffic. In course of my investigation, your Lordship, this is important, this para. In course of my investigation and examination of the witnesses present, who was some police officer deputed in the said highway for Naka checking, namely SI Johun S. Sangma and SI Iamba M. Kharbi, who saw that the Maruti car driven by Shri Colin Wajri from Barnihat side to Shillong, whose coming in excessive speed in a rash and negligent manner from Barnihat side towards Shillong. He is referring to the statement recorded by him of these two officers, and who has stated him that according to them that Maruti car was coming from Barnihat side to Shillong in excessive speed in a rash and negligent manner from Barnihat side towards. The two officers signaled to stop, but ignoring the signal, the Maruti car drove off, overtaking the vehicle. Being checked by the two officers, then it went and dashed against the truck number so and so, which was moving at this normal speed and on the correct side of the road of the Barnyard. This, your lordship, important because what statement the IO has recorded of these two witnesses that the truck was moving at normal speed and on the correct side of the road towards Barnyard, meaning thereby that the truck was not parked, it was moving. And that's what he recorded. And on the basis of which he has submitted the FR. The FIR in connection with this accident was filed by SI Johun S. Sangma of Nongpo PS, who is the one of the officers during the Naka checking and who had witnessed the accident. Paper mark A is the FIR dated so and so, signed by SI Johun S. Sangma, and A1 is the signature which I know, the certified copy which was available. The vehicle which was involved in the accident, which was seized by me, paper mark B is the seizure list of so and so, and my signature, and seizure list Maruti cars so and so. I also obtained the post-mortem report from DMHO Civil Hospital Nongpo, and as per the report, the contents in the stomach contained digestive food and smell of alcohol was present. Paper mark D is the said post-mortem report. Now, your lordship, at this one I may point out that the doctor who conducted the post-mortem was not examined. That to prove the post-mortem and the contents of the digestive food and the smell of alcohol. Yes. In course of my investigation, I have found that an examination of the eyewitness, I found that the said accident was caused due to the rash and negligent driving of the Maruti car and the consequent dent of serious colon injury the driver of the Maruti car. I have registered a UD case being number so and so and submitted my final report, which is paper mark E, along with all the enclosure, and paper mark E1 is my signature. The original of all documents which I have produced are exhibited in the Nongpo court. Then cross-examination. I confirm and say that I was not present at the time of incident at the place of occurrence. He was not present. It is also correct to say that I have not witnessed the accident by my own eyes. I also state that since the vehicle involved in the accident has been removed from the place of occurrence, as such I could not prepare the sketch map. I state that apart from the police officer deputed in the highway for Naka checking at the time of accident, I have also examined the occupant of the Maruti car, as well as the driver of the truck, and no one else, as nobody was available as it was quite late. I state that the statement in respect of the manner in which the accident took place and the statement recorded by me and version of the other witness are not my own statement, as I have not personally witnessed the accident. I further state that I am aware that a regular case against the driver of the truck has been registered subsequently. I am also not aware about the fate of subsequent case. Then, your lordship, this one is important. Next line. I also agree that the fact of ordering a re-investigation into the case also goes on to show that the FR paper mark E submitted by me before the court had been rejected, your lordship. Yes. It is a fact that since I was not present at the time of accident, the PO, I cannot say how the accident took place. Now, Your Lordship, come to this is the IO's statement of the UD case, and he admitted that since a regular case, my FR stands rejected. Then, Your Lordship, cross-examination of OP number 1. Examination chief, page 39, Your Lordship.
Yes.
OP number 2. He was present at the Nakab duty. I have received summon to appear before the court to give evidence in this case. On June so and so, I posted Nongpo PS police station. On 11/6/2014 in the evening, we were detailed by the OC Nongpo PS for conducting highway. SI Johon Sangma was with me and some other personnel whose name I do not recall now. In course of the vehicle checking at the highway, we stopped many vehicles and everybody obeyed our signal and stopped their vehicle for checking. Suddenly one red Maruti car in a rash driving came from Banihat side towards Shillong, and when we signaled the vehicle to stop it, it did not stop but rushed towards and dashed the stationary truck on the opposite side, Your Lordship. There is no pleading to this effect, Your Lordship. They have not pleaded this case and thereby deprived me of bringing any evidence on this point. Anyway, whatever be that it may be, from that itself, Your Lordship, I will prove it. That and dashed the stationary truck on the opposite side. He is coming up with another statement, another stand, that this vehicle dashed against the stationary truck. But IO has stated that truck was moving, and this observation, he said, I have made from the evidence of the statement recorded by me of the other 2 police officers who were present. To the IO they say that it was moving, but in the court they say no, truck was stationary. After that, we informed IC traffic and called the ambulance and took the injured to the hospital. This accident I have witnessed with my own eyes, and according to me, the red Maruti car was at fault. On the next day, I learned that driver of the said Maruti car succumbed to his injury. My statement was recorded by the IO. He admits that his statement was recorded by the IO. The IO of the case is Srimati so-and-so, that is all. Then in the cross-examination, he says, I can recall on the day of the incident. I cannot say whether the occupant of the Maruti car had received injuries, not, but he looks injured. I cannot say if the statement of the injured occupant was recorded by the IO. I do not agree whether the injured occupant is the vital witness in the accident case. I do not agree that the driver of the said Maruti car drove in a jig-jig manner. I cannot say which part of the red Maruti car got damaged. It is correct to say that the red Maruti car hit the front side of the stationary truck. That is all, Your Lordship. Your Lordship, if at all contradiction is to be found, contradiction is in the evidence of OPW1 and OPW2. OPW-IO, who recorded his statement, he says that these people have informed me that the truck was moving. But in the court they say that no, the truck was stationary. Then, Your Lordship, they examined other person, Johon S. Sangma, page 41. He is OP number 3. I have received summon to appear and give evidence in this case. I was posted at Nongpo police station on 11/6/2014 in the evening from 7 p.m. We were on highway duty for Naka checking of all the vehicles passing through Nongpo. At that time, my colleagues UBSI so-and-so was also with me. At the relevant time, we were stopping the vehicle through that route and checking the vehicle. Suddenly, one red Maruti car vehicle going towards Shillong was stopped by us, but it did not stop. The red vehicle was driven in a rash and negligent manner. The Maruti car did not stop our signal and went forward and hit one truck which was parked on the side of the road. The accident took place at around 9 p.m. and we were not nearby, standing on the road. We rushed to the spot and took out the driver of the Maruti car. At that point of time, we do not know whether the driver of the Maruti car was alive or dead. I have seen the incident with my own eyes and it was the fault of the driver of the Maruti car. After that, I do not know anything as the traffic police branch took over the case. The investigating officer IO of the case had recorded my statement. That is the chief. Nothing so important comes out in the chief. In the cross, your lordship, I joined the sub-inspector at Police Meghalaya on so-and-so. After completion of my 1-year training, which I completed in December 2013, I was posted on probation as sub-inspector in Rivoy. It is a fact that prior to the date of accident, I never to work in the traffic branch. Similarly, the OP number 2 had also joined as sub-inspector. I cannot say whether OP number 2 has worked in the traffic department prior. Though I had not worked in the traffic department prior to the incident, but I was aware of the traffic rules. At the relevant time of the accident, I was looking towards Nompo. It was my colleague who tried to stop the Maruti car. He did not try to stop the Maruti car, but other witness, he has not stated that he tried to stop the car. The road on which the accident took place is a national highway. At the relevant time, it was not 4-lane, but under construction. It is a fact that as per traffic rule, no vehicle is supposed to park on the national highway. Your Lordship, this is important. If at all we take the stand of these two witnesses that the vehicle was parked, now he says that as per rule, no vehicle is supposed to be parked on the national highway. So, assuming that their contradictory theory is correct, then your lordship, the truck has violated the rules that it was parked on the national highway. It is a fact that the driver of the truck is not supposed to park his vehicle on the national highway as per traffic rules. The accident took place at around 9 p.m. Though it was dark, there were street lights at the place of accident. 13. It is a fact that when the vehicle was parked on the roadside, the driver of the vehicle is supposed to switch on the parking lights which blinks. Question. Whether you will agree with the suggestion that the person who is sitting beside the driver of the Maruti car is a better person. He answers, the person sitting beside the driver of the Maruti car was drunk. When my colleague tried to stop the Maruti car and the Maruti car did not stop, I started looking towards Guwahati side. I have seen that the truck which was parked had its half light on, but parking light which blinks. Your Lordship, he doesn't say that. He says that I have seen that the truck which was parked had its half light on. It is not a fact that I have not seen the half light of the truck was not on since I was looking at the Guwahati side. I do not know as to whether initially so-and-so unnatural death case was registered, and I also do not know whether regular case was registered. I have given the same statement of what I have deposed today before the IO. I do not know whether I had given the statement in UD case or in the regular case, Your Lordship. On being, then 22, on being shown the statement of OP number 1, IO, he's IO, Your Lordship, then I went and dashed against the truck number so and so, which was moving at the normal speed on the correct side of the road towards Banihart, because IO has stated that witness have told him that the truck was moving. Then in the court what he says, I say that the truck was not moving but it was parked. He contradicts the statement of the IO that no, I did not say, meaning thereby that he said that the truck was not moving, it was parked. IO has recorded that he has stated that the truck was on the, your lordship will see the kind of evidence.
He says it was stationary, it was parked,
Yes, yes,
but you say it was moving.
it was moving. And IO has stated that these witnesses have stated that truck was moving. Now, your lordship, I take to your lordship page 51. Page 51, this is the first accident report, your lordship. First accident report.
Yes.
Now, your lordship, in between I will take it. Let me read the small para. The brief of the case is that on 11/6/2014 evening, on a receipt of accident report, the PO, that is Nongpo proper, just before so and so, visited by Inspector C. Sheila so and so, found that one private Maruti car bearing registration numbers on the main road, lying in a damaged condition, with the injured driver, one occupant inside the Maruti car. Immediately, without losing time, both the driver and occupants were taken out of Maruti car and removed to Nongpo Civil Hospital by the help of the 108 ambulance, accompanied by the police for treatment. The driver of the Maruti car, who was seriously injured, suspected to have died on the spot inside the damaged car. On further inquiry, it is learned that on the same evening, the driver of the Maruti car, Shri so and so, accompanied by one occupant, Shri President William, 29 years, son of so and so, was proceeding from Banihart towards Shillong side, and on reaching at Nongpo proper at about 9 p.m., just below Nongpo police station, met with an accident against one truck bearing number so and so, driven by so and so, which was coming from opposite direction and proceeding down towards Banihart side. Your lordship, in the first accident report submitted by the IO after examining these two witnesses, also shows that the truck was moving. From Banihart to Shillong side, Banihart to Guwahati side. The driver of the Maruti car, who was serious, declared that this is what I want to show, that in the first accident report itself, it is mentioned, your lordship. Then, your lordship, I take to page number 56A, that is the FR submitted by the IO. Then your lordship, page number 56C, order dated 6/11/2014, by which re-investigation is ordered. Then your lordship will see page 57. The regular case is registered against the driver of the vehicle number so and so, that is Maruti car.
Yes.
Under the section 279/304A. Now, this FIR which is given is at page 58. This FIR, your lordship, is registered, is given by, this is the second FIR submitted for the registration of a regular case. Now, regular case is registered, but and HM same SI is the IO of this regular case.
Yes.
Now, page 97, your lordship will find the photocopy of original FIR, which is marked as paper mark A, and this is given by SI Johun,
Page 97.
page 97. No, this is for your lordship UD case, the first FIR, on the basis of which a UD case is registered. SI Johun is the OPW2. Then your lordship, may I go further?
Page. Page 98 is just Sigillis.
No, your lordship, I am just pointing out now, page number 100B, capital B. This is part of the postmortem report, which is reflected in the order.
This is on the basis of the second FIR.
Yeah, where it is mentioned that healthy digested food, healthy and digested food matter smell of alcohol presence, your lordship. Now, I'll make some, this is not the part of the order on the basis of which the issue was decided. Observation is there. I pointed out in paragraph 61. But the findings are written on the basis of the evidence of OPW2 and OPW3, and by discarding the evidence adduced by me.
Yes.
Then your lordship, page number 101 is the FR of UD case, page 101.
No, that second FIR, was any charge sheet filed?
No,
FR. There are two
because
FR.
it was registered against a dead person, so they filed FR. But that FR has not come on record, of course. But my information is this, that since they registered the case against a dead person, so question of investigation even does not arise here.
Even the issue of abatement will come. Anyway.
And here, page 101, your lordship, is the FR of UD case. In the last line, your lordship will find that last line, coming from Banihart side, the said Maruti car was seen moving in excessive speed from the same direction.
Last line?
Last line of page 101.
During investigation?
Yes. Here, your lordship, from the FR of UD case, lordship will find that both the vehicle were moving from opposite directions. And page number 102, the driver of the car was given signal by the police to stop his vehicle, but instead he overtook the vehicle which was being checked, and unable to control its speed, straightway dashed the said truck coming from the opposite direction. There are ample evidence, both oral and documentary, that the truck was moving. And my case is that this truck overtook another vehicle, for which there is no challenge. And I have pointed out the MVI report on the last occasion, and I have shown that damage to the truck is on the front bumper and number plate. Number plate is in the center, Your Lordship. So that itself shows that accident took place because of the head-on collision on the part of both the vehicles, Your Lordship. Then similarly, Your Lordship, at MVI report of the Maruti car will show that the Maruti car was totally damaged, Your Lordship. Now, one of the plea of this witness is also this, that after seeing the Maruti car, what efforts he made to avoid the accident, because truck is a heavy vehicle. Yeah. The responsibility lies upon the truck to make some efforts under his control. He has seen the Maruti car coming. He ought to have taken the vehicles in some other direction. He suddenly stopped. So, this being Your Lordship, the position of the evidence, the court has, the learned MACT has, the learned court has taken a most technical view of the just hold it. Your Lordship, I just point out the judgment on 2023, volume 13.
On what point?
That the tribunal in the accident case has to decide the question of negligence not in the manner as is to be done in the criminal trial. It is a technical view. The most technical view cannot be taken here. It depends upon the preponderance of the evidence, Your Lordship, not on the strict proof of the evidence. So here the court has also Your Lordship will see paragraph 11, 2023, 13, Matthew.
Para 11.
Para 11. Insofar as the claim petition filed by the appellant herein is concerned, alleged negligence on the part of the driver of the tanker lorry and pickup van in causing the accident has to be proved. That's a matter which has to be considered on the basis of the
23.
That is the matter. Insofar as the claim petition filed by the appellant herein is concerned, alleged negligence on the part of the driver of the tanker lorry and pickup van in causing the accident has to be proved. That is a matter which has to be considered on the basis of the preponderance of the possibility and not on the basis of proof beyond reasonable doubt. it is left to the parties in the claim petition filed by the appellant herein in order or other claimants to let in their respective evidence, and the burden is on them to prove negligence on the part of the driver of the Alto car, the tanker lorry or pickup van, as the case may be, in causing the accident. In such an event, the claim petition would be considered on its own merit. It is needless to observe that if the proof of negligence on the part of the three vehicle is not established, then in that event the claim petition will be disposed of accordingly. So, Your Lordship, is very clear here from the judgment of the apex court that it is a probability, that possibility, and a holistic view has to be taken. This is social legislation. Now, another important thing Your Lordship will notice, insurance company has taken over the defense of the driver of the truck.
Yes.
They ought to have summoned him. No, what has actually happened, either is in the knowledge of the driver of the Alto car or of the driver of the truck. My driver died. No, his driver was alive. They make no effort to call him. Neither he himself graced the witness box, nor he enters. But fortunately, he makes an appearance, sudden appearance, surprising appearance before my Lordship. Whereas his defense is already taken over by the insured, by the insurance company. The best person which ought to have been examined was the driver of the truck, and they failed to examine him. Now, in the accident, the facts will speak, and my submission is also this, that doctrine of res ipsa liquidator is squarely applicable in this case. I have proved that accident has occurred because truck was moving and he overtook the other vehicle, and as a result accident took place and the person died. Then the burden is shifted upon the insurance company, who took over the defense of both. Now they come up with the contradictory stand without filing any written version. No additional written statement comes before the court. Now, on the res ipsa liquidator, Your Lordship may note down.
We will continue, Mr. Linder.
Sir,
We'll continue next time.
And I will take only 10 minutes more, if Your Lordship permit. 10 minutes
We
more.
may not have time.
Within 10 minutes, I will close. Just give the citation. 2005.
This is on
Res ipsa liquidator. On the grounds on which or the circumstances under which this doctrine would apply.
Yes.
2005, 3 SEC 241, para 25 and 26.
Yes.
Now, one more submission, Your Lordship, before raise is this, that case is 11 years old. Now, this court, Your Lordship, being the first appellate court which can go into the facts. Now, remand of this case, if Your Lordship comes to the finding and set aside the decide the question of negligence, if Your Lordship remand the case back again to the tribunal, for deciding the other issues, 11 years, your lordship, I have already suffered. And to have a second round of litigation before other tribunal will be very highly prejudiced, your lordship.
No, if that possibility arises, then we will see what would be the option.
Yes, lordship.
This court has not come to that conclusion.
No, not yet. Not yet. In the event it comes. In the yes, after hearing you, but definitely I am not
Reserve this submission.
And I'll place one judgment of the Supreme Court on this issue.
You can reply on that. After he finishes, you will reply on that point.
Yes, I concluded.
We'll continue next date then.
My lord. Just give a date, your lordship, when your lordship is not having DV with the.
That we cannot say because the roster is such that.
No, roster, I mean, remains same now.
No, roster, I mean, the fact that I am having DV.
Friday. My lord, will it be convenient to your lordship to fix it on 25th
no,
and there is the next
25,
Friday?
no, not possible. I think we have many cases.
You have completed, no?
No, it's not possible.
Since he is completed.
No, but I have to be present, no, because I have got important cases in other, two important cases.
Can you suggest a date? Suggest a date.
Suggested date.
Date. 21st. Monday, where can we take?
Monday I am too occupied. 20, if it is not
22.
He says 25th I am ready.
25th, on 25th I am not ready.
Fine, we'll fix it on 28th then.
Yes, that's okay. 28. Either 25 or
28.
You have concluded your.
I have concluded.
Mr. VK General, Learned Senior Counsel, has concluded his argument. The respondent is to reply on the next date fix. As agreed to by the parties, this is matter on 28.
Much obliged.
Item number 4.
Item 4. Come. Yes, what is the situation?
I had a word with Mr. Gautam also, so it appears that the process is still on.
Settlement talks are still going on, Lordship. The next sitting is on Monday, Lordship.
Next sitting?
Yeah, Lordship. So 2 weeks may be given, Lordship.
It is submitted, Learned Counsel for the parties has submitted at the bar that the process of settlement and negotiation between the parties is still going on, and the next sitting is fixed on 21. Accordingly, sometime is paid for this for this matter to be for
Monday is the next sitting.
Accordingly, it is prayed that this matter will be adjourned for a day. 2 weeks.
2 weeks. My lord, it will take some more time because my instructions are that the settlement is in progress. The negotiations are in progress.
That's what he said.
So it will take some time. Let it come after 3 weeks.
This is matter up to 3 weeks.
Item number 5.
Lords, this is that matter regarding the Customs Act.
Yes.
Served copies? Where? Haven't you served? To state. So you have to serve to everybody. My lords, my lords had called for a report from the state. They had filed it by way of an affidavit. We filed our exception to that. We filed our affidavits. Only issue is, my lords, this matter will take a little bit of time. If my lords so desire, my lords, we can begin, but then it will take a bit of time. I don't know with
Okay,
positive.
we'll have time today. You suggest a date? No?
Then 24th, I think.
24th, my lords, next week.
27th, we can
Subject to my lord's convenience, of
No,
course.
not 24th, Your Lordship. His Lordship, then he will come
25th.
29 or 30, Your Lordship.
Yeah, from I think
29.
due to paucity of time, this matter could not be taken up. M9 Act. As agreed to Mr. A. Paul, Learned Senior Counsel, appearing for the petitioner, has Aikani Hakatu Committee Case 164, submitted that the response to the compliance report filed by the state respondent compliance report was filed on 17/2.
My lords, 10th of July, my lords.
10/7.
My lords.
This is compliance to the order dated 17/2.
Lordship, yes.
No, my lords, it's compliance to the order dated 26/6/2025.
Then where does this date comes from?
I'm sorry, my lords.
17/2.
No, Lordship, there was an Lordship.
My lords, the original order was of 15/12/2024.
An objection filed by so and so on behalf of respondent 6. You are respondent 6 in 164. Bring on record the compliance report dated 17/2/2025. This is your response, isn't it?
My lords, this is my response. My lords.
What is this 17/2?
Show me.
17.
My lords, there is a typo error, my lord.
This is then this will create more confusion then.
My lords, lordships may kindly give us liberty to correct this.
Do it by hand.
My lords.
What is the date?
It is 5/12. Yeah, these typo errors coming in. My lords, it's correct. As a matter, it's correct. As a matter of fact, the letter, my lords, which has been filed by them is dated 17/2. But the problem is, my lords, the forwarding letter is dated 17/2, but the order of the court was on an earlier date, my lords.
Exactly.
My lords.
Actually, you should go by the order of the court.
Order of the court.
Well, it's because this says an objection filed for and on behalf of respondent number 6 in reply to the affidavit filed by the state bringing on record the compliance report dated 17/2. The report is dated 17/2.
Report.
Report is dated 17/2.
Yes, correct.
Now you're seeing again July 10 July.
It was filed on 10 July, Your Lordship.
What had happened is, my lords, there was an order passed way back last year, my lords, on 5/12, calling for a report. But unfortunately, my lords, it was not brought on record. Then we pointed out before my lords on the last date, and this court, by order dated, my lords, 26/6/2025, had directed them that steps have been taken on that. So, my lords, now they have filed an affidavit on the 10th of July, bringing on record the compliance report dated 17/2/2025. That's how the confusion has arisen.
There is no confusion.
In my mind.
Because the matter was never taken up, so we just get the inputs.
Compliance report dated 17/2. Filed by this state respondent on 10/7. The objection dated 18/7/2025 has been filed accordingly. As prayed for by the parties, this is matter for further hearing on 29th.
29th of July. Highly obliged.
Obliged.
Put it on my calendar.